Your body, your rights. Speak up, stand strong.
Recently, there has been rising concerns of sexual offense cases in Malaysia, especially among youths in their 20s, particularly university students.
Today, we will discuss the relevant laws under the Penal Code to better understand the protection in place against sexual offences in Malaysia.
Now we'll be passing to our data analyst, Yumi. Yumi, are you there?
Yes, Yumi here, presented with the data. As of late 2024, there are 4,217 reported cases of women in domestic violence, rape, and sexual harassment instances nationwide. 1 in 5 university students reported sexual harassment in the duration of their university life, but only 11.1% took action. Nationwide, there are 1,582 reported rape cases in 2021. We have specifically prepared a segment where we discuss your rights and how to protect yourself against sexual offenses in Malaysia.
The main provision under the Penal Code that protects us from sexual offenses is Section 375. This section states that an accused, who must be a man, have committed sexual intercourse under the circumstances listed in this section, which will be explained later on in the video, towards the victim, who must be a woman at birth. However, it is important to note that an offender can only be charged if he does not fall under the exceptions of this section, which will also be explained later on in the video. The explanation to this section states that sexual intercourse means penetration. However, subsequent Malaysian court cases have provided more explanation and clarity as to what sexual intercourse or penetration means. Nasrul's case stated that penetration has to be done with the penis, while Sidek bin Budan's case stated that slight penetration is sufficient, which means that the victim does not have to show that the hymen was broken. It's enough to show that the victim was penetrated by the accused. Cheng Yu Hoi's case stated that there is no need to show ejaculation to confirm penetration. And Ahmad Najib's case confirms this, saying that while evidence of semen can be submitted to prove that there is penetration, it is not a must for the victim to show that, or the prosecution to show that. Therefore, by combining all the points provided by the Penal Code and Malaysian courts, we can conclude that sexual intercourse is an act of slight penetration with the accused's penis of the victim's vagina.
Section 375, subsection A of the Penal Code talks about against her will. This means that if the woman is forced unwillingly, or if she had been coerced into the act, there are no signs or means of interest, and there is involuntary decision to partake in the act. The second circumstance falls under subsection B, without her consent. Consent is when permission is given. However, there is a difference between submitting and consenting. For instance, a person may give into sexual acts that results in no physical resistance. However, this does not mean consent is given. In the case of public prosecutor against Lee Seopong in 2016, consent is defined, having the free will, knowledge, and choice. If none of these are satisfied, the person can be said to not have consent.
Section 375C is about consent obtained by fear or misconception of fact. This section addresses situations where consent is not truly voluntary. For instance, consent is not considered genuine if a woman agrees out of fear for her life or her safety. Likewise, if a man deceives a woman into consenting by knowingly lying about crucial facts, this is also regarded as rape. To illustrate, if a friend threatens you by saying, "If you don't agree, I'll hurt you or your friend," that consent is given under fear and is not valid and is punishable as rape. In the case of Tae Hee-hyung lawan Penal, the perpetrator manipulated the victim by instilling fear of supernatural harm and death, coercing her into sexual acts. The victim was terrified because she believed that if she didn't comply and have sex, she would die by March. This demonstrates that her consent was not freely given, but was instead coerced through fear. Section 375 Section D of the Penal Code criminalizes situations where a woman consents to sexual intercourse under the mistaken belief that the man is her lawful husband, as this deception invalidates her consent. For example, in the scenario we acted out, the woman believed she was with her husband, but in reality, it was his twin brother. This deception rendered her consent invalid and is punishable under Section 375 subsection D.
Next, we come to section 375, subsection E of the Penal Code. This section basically says that if the victim consents to the sexual intercourse but they don't understand what they are agreeing to or the consequences of that intercourse, then that consent is not valid. Examples of victims covered include victims who has mental incapacity, such as a victim who has dementia with a mental age of a 5-year-old agreeing to have sex but do not know what it means. Another example are victims who are heavily intoxicated, such as a girl who is drunk at a party agreeing to have sex with a stranger without understanding what she's getting into. Lastly, cases where there is temporary incapacity, such as a victim who is heavily sedated from a surgery procedure agreeing to have sexual intercourse when she is incapable to make rational decisions of her own because of the medication. Moving on, we have section 375 subsection F of the Penal Code, which states that where a person obtains consent to have sexual intercourse by misusing their position of power or trust, then that consent is not valid. Examples of relationships covered under this section is employer and employee relationships, such as when the boss offers a promotion to his staff if she agrees to have sex with him. Teacher-student relationships is also an instance where the teacher would offer better grades for the student if she agrees to have sexual intercourse with him. Lastly, in cases where a doctor misrepresented the sexual intercourse as medical treatment for his patient to obtain her consent, then that consent would be invalid.
Next, we have to discuss the idea of consent, as it is important to prove that the interaction was non-consensual on the victim's end. Consent is laid out in the Penal Code in 2 different sections. Section 90 says that consent is not valid when consent is given by a person not of sound mind, such as being under the influences and/or when drunk, or when instilled with fear, or when person is under the age of 12. More specifically, Section 375G states that a person cannot give consent for sexual activity if they are under the age of 16. Meaning legally in Malaysia, the age of consent is 16.
However, as mentioned earlier in the video, Section 375 is also inclusive of an exception. The exception given is that a man cannot be charged for raping his wife. As long as they are married, the husband cannot be said to have raped his wife even if he satisfies anything under subsection A to G that we explained earlier. This position is final unless the spouses have judicial separation, which is a court order for them to live separately as a way to formalize their separation, but they are still married. A decree nisi is a temporary court order in divorce proceedings where the court acknowledged the ground of divorce, but the divorce is not finalized yet. So until the court makes an absolute order of decree nisi, then they would still be legally married. Another exception is when the wife got an injunction from the court preventing her husband from having sexual intercourse with her. The last exception is where a Muslim woman is living separately from her husband during the iddah period, then she will not be recognized as his wife.
Section 375 of the Penal Code includes an exception known as the marital rape exception. It states that sexual intercourse by a husband with his wife in a legally recognized marriage is not considered as rape. This reflects a traditional view that marriage implies ongoing consent to intimacy. However, today we understand that consent is an ongoing process, not just one-time agreement. To address extreme cases where a husband forces sexual acts through threats or harm, Section 375A was introduced. While this provision criminalizes coercion through violence or threats, it does not recognize marital rape outright. This creates a gap in protection, as the elements required under Section 375A differ from those of rape under Section 375, leading to unequal treatment of married and unmarried women. This raises the need to reflect on whether our laws like Section 375 and 375A is fully aligned with Malaysia's commitment under the Federal Constitution, CEDAW, and other frameworks promoting women's rights. As university students, you can make a difference by researching, participating in legal discussions, and also working with NGOs to push for laws that protect everyone's rights, including those of married individuals. Section 375B addresses gang rape, which occurs when a woman is raped by one or more individuals acting with a shared intention. Each person involved in the act is considered to have committed gang rape under this section, regardless of their direct role. For example, at a university party, a group of students acting together just taking advantage of a classmate. Even if only one person commits the act while the others aid or encourage, all can be charged with gang rape. The example highlights how group dynamics can lead to such crimes. In the case of Ahmad Muslim Hakani bin Rosli dan lain-lain, lawan pendakwa, the victim was raped by 3 individuals who took turns committing the act. The court found that the perpetrators acted with a common intention to rape the victim, fulfilling the criteria under Section 375B. This provision is especially important in a university setting, where peer pressure and group dynamics can sometimes lead to serious offenses. It sends a clear message that any group involvement in sexual offenses will not be tolerated. Understanding this law helps students to recognize the gravity of such actions and the severe consequences that follow.
First of all, I will be going over carnal intercourse against the order of nature, covered under sections 377A, 377B, and 377C of the Penal Code. These provisions criminalize unnatural sexual acts involving penetration, such as anal or oral sex, whether between individuals of same or different genders. Section 377A defines the act itself, while 377B outlines the penalties for those convicted under 377A. The punishment can be as severe as 20 years in prison and whipping. Section 377C takes the step further, focusing on acts involving minors under the age of 16, with penalties extending to 30 years imprisonment and whipping. An article by Malaysia Kini critiques the law's continued use in Malaysia today, questioning whether it serves any practical purpose other than reinforcing heteronormative ideals and marginalizing LGBTQ+ individuals. The case of Dato Seri Anwar Ibrahim against public prosecutor involving sodomy allegations under Section 377A highlighted the strict penalties for such offences in Malaysia, underscoring the law's seriousness regardless of status, despite political overtones. In relation to heterosexual relations, courts recognize that oral sex, when part of consensual heterosexual foreplay to intercourse, would not violate Section 377A. However, oral sex as an act itself as a substitute to natural intercourse remained unlawful. Sections 377A and 377B face criticism for failing to distinguish between consensual and non-consensual acts, raising concerns about penalizing consensual behavior and infringing individual rights. Human Rights Watch argue that laws like Section 377A are often misused to stigmatize and marginalize LGBTQ+ individuals. On the other hand, Section 377C protects minors by severely punishing sexual assault offenders, reinforcing its role in preventing exploitation. For students, understanding these provisions emphasizes the importance of consent and personal boundaries in interpersonal relationships. While the laws aim to provide protection, it's vital to be aware of how they function and the potential implications of their enforcement. This awareness not only helps you to stay informed about your legal rights, but also encourages responsible behavior within the framework of the law.
Under Section 377D of the Penal Code, outrages on indecency. Explanations as to what are outrages on indecency is that indecent exposure, indecent touching, indecent of acts that involve children, which are exposure of private parts, touching a person in a sexual manner without consent. It must also be noted that these acts of gross indecency would vary depending on the circumstances and specific contexts. This would also include any acts that is morally offensive to the average reasonable persons. A case that is notable to be mentioned under outrages of indecency is the case of Sukma Darmawan Sasmita Majda in 2007, where there is an alleged act of sodomy, which is oral or anal intercourse.
In Section 377CA, it is said that it is punishable if there is penetration by a foreign object without consent. Any other foreign object that are not private parts would suffice. In both the cases presented, there was an insertion of object, which in these cases are fingers, to the victim under the age of consent. This is then considered as sexual violation by the courts. Therefore, they were punished for the actions.
Now, I will be discussing on incest, which falls under Section 376A of the Penal Code. Incest is defined as sexual relations between individuals who are legally, culturally, or religiously prohibited from marrying due to their close familial relationship. This includes relationships between siblings, parents and children, or other close relatives. The punishment for incest is severe, ranging from 10 to 30 years imprisonment and whipping under Section 376B. In the case of Mohammed Zandiri bin Arifin against public prosecutor, the offender was convicted of incest, which brought significant harm to the family and psychological damage to the victim. This case illustrates the importance of these laws in preserving familiar boundaries and protecting individuals from the abuse within the family structure. The Rugged Post highlighted a troubling statistic where over 1,100 incest cases were reported in Malaysia between 2017 and 2021, with many involving biological fathers as perpetrators. University students should be vigilant in recognizing and reporting cases of incest, as it is a severe crime under Section 376A of the Penal Code, with penalties of up to 30 years in prison and whipping under 376B. Students should understand that incest can have devastating psychological effects on victims and disrupt familial structures. Universities can provide a supporting environment by offering access to counselors and confidential reporting mechanisms. Incest often goes unreported due to cultural stigma, fear, and close relationship between the perpetrator and victim, which makes seeking help particularly difficult for survivors. If students suspect or know of cases within their families or communities, they should reach out to trusted authorities or helplines for assistance.
Under Section 377 of the Penal Code, which is buggery with an animal, this basically means that it is whoever who voluntarily has carnal intercourse with an animal. This may be with a goat or a horse. The explanation to this is that penetration is deemed sufficient to constitute the carnal intercourse necessary to offense what is described under this section. An example, in 2021, a senior citizen was jailed for 6 years after having carnal intercourse with a goat behind a house in Kampung Sungai Buaya, Malaysia. This was also considered an offense of buggery with an animal.
In conclusion, we hope that this insight has been helpful for university students to better understand the protection against sexual offenses in Malaysia.
Thank you for tuning in. We hope to see you again soon. Your body, your rights. Speak up, stand strong.